G'day everyone and welcome to our long overdue but well worth waiting for, hopefully, our final video for the Legal Studies Guide 4.2.13. Our quote today comes from Winston Churchill. Now, a man of many great quotes, Winston Churchill. Not all of them things that he actually said though, and actually not as good a man as sometimes he's made out to be with some of the decisions he made in British overseas territories like India. But nonetheless, we do like this quote at the Legal Studies Guide. If you're going through hell, keep going. This time of year, I imagine there'll be a bunch of you that are quite anxious, feeling quite a lot of stress, and I suppose worried and overwhelmed by SACs and the upcoming exams. Look, it sounds, probably stuff you've heard before, and I don't want to be preaching too much, but if you just stand still and don't stop moving and stop moving and I suppose give up a little bit, then it's not going to get any easier anytime soon. And the only way through it is just to keep going and keep moving forwards. And that's what we're going to do with video 4.2.13, which is the ability of Parliament and the courts to respond to the need for law reform, aka the ability of Parliament and courts to change the law. Like, law needs changing. Can they do it? Are they good at it? And effectively, it's what we've been looking at throughout this entire area of study. Earlier on, 4.2.1, we looked at factors that affect the ability of Parliament to change the law. So these are things that affect the ability of Parliament to respond to the need for law reform. 4.2.4, we looked at factors that affect the court's ability to change the law. So the ability of courts to respond to law reform. So we've looked at these limitations anyway. So it's just rehashing stuff with this video here, and we're going to be able to answer how good are Parliament and the courts at responding to the need for law reform. And we're going to go straight to the skill, because there's no point looking at the content. It's stuff we've gone over before already. So we're literally going to go straight to the skill. We know when we're evaluating something, we have to come to a value judgment. We have to come to a justified argument about how good something is or how much of something you can have. So with this, evaluating the ability of Parliament and the courts to respond to the need for law reform, we are just coming to a value judgment on how good is Parliament at reforming the law, okay, or responding to needs for law reform. How good are the courts at reforming the law? And really simply, I've got two tables, one for Parliament, one for the courts, how they're good or how they can reform the law and respond to needs for law reform, and how they can't. So with Parliament, it is pretty straightforward. Again, not going to go into great detail over stuff we've already done. You can look back on this if you want. Parliament has access to expert opinion. Okay, they can use the VLRC, they can use royal commissions, they can use parliamentary committees. They have an extensive process for passing the law. Therefore, we know that any law reform issue is going to be well investigated, considered and debated, and the decision is going to be made in the best interests of the public. As well as this, because members are elected into office by the public, they are accountable to the public. So they're only going to reform the law in ways that the people actually want. However, this process of getting all this expert opinion, etc., can be really time-consuming, and particularly if the opposition doesn't agree with the roles of the House of the Parliament, then Parliament might not actually be able to respond to any needs for law reform. And as well as this, if the fact that they're accountable to the people, so they're going to make law reform needs, or going to reform the law in line with the needs of the public, they might also at times fear voter backlash from vocal minorities or selfish majorities. So they might not actually change the law, for example, to support a minority group if they're not likely to actually get support from the majority group for this. So think about things like same-sex marriage. Every single public poll that was held in Australia, opinion poll, indicated that the public was supportive, but politicians were still really reluctant to actually just change the law there and ended up holding a plebiscite to do it. As well as this, you've got to vote along party lines, which means you might not actually be able to to represent the interests of people in your electorate. However, ultimately, Parliament can change the law on any topic at any time, provided it's within their powers, although sometimes they can't act quickly, sometimes things aren't within their powers as well. They might also not draft legislation very well, can cause confusion and lengthy court cases, statutory interpretation, etc. but they can pass laws onto an entire topic. It's not like the courts who are just interpreting one matter in front of them or one word in a statute. They can legislate for an entire area, like medicinal cannabis. Here's an entire piece of legislation going through Parliament, the Medicinal Cannabis Act, that covers everything to do with access to medicinal cannabis. So that idea of Parliament's great at responding to law reform because they can cover the whole area. We've also got this extra new point down the bottom, which some of you might know from year 11, hopefully, but it might be new to some. Parliament can delegate its lawmaking powers to things like Vic Roads in Victoria, etc. Victoria Police has some ability to enforce the law and create regulations, etc. This saves time, adds expertise in, which means we're going to respond to law reform quickly and effectively. However, these subordinate authorities generally aren't elected, so that might be seen as not actually being in line with Parliament's function to represent the people. Courts are even more straightforward, I think, than Parliament. This is the massive one. If we are going to talk about courts reforming the law, we can focus on things like judges are often activists, which means they might be able to make decisions that Parliament wouldn't. When they're not bound by a precedent, they can make their own decision, etc. But ultimately, courts can't actively reform the law. They have to wait for a case. The right legal arguments have to be made. Someone has to have standing, so on and so forth. And at the end of the day, Parliament can abrogate any law reform through the courts anyway. So ultimately, courts can't really reform the law unless the opportunity is perfect, unless all the stars align, make sure they're not bound by a precedent, make sure they're not bound by a statute, make sure the right arguments are made, someone brings a case in the first case. And even if all that happens, sometimes judges won't change the law anyway because they're conservative. The high costs are going to stop people bringing a case as well. And this one should actually be over here. And this is the idea that they can only reform the law in a really narrow manner. They can't legislate over broad topics and reform broad areas of law like Parliament can, because they can only deal with the matter in front of them. However, the courts can reform the law when there's no statute, so a novel fact situation, or when they're not bound by a precedent. And this whole idea of judicial activism means courts can change the law on controversial issues where Parliament may avoid. So a key example of that is the Mabo case. Controversial issue about Indigenous land rights in the late 80s, early 90s, and the court could just make the decision that was a right rather than the decision that was necessarily popular. This is the ultimate link, and this link covers basically every video we've done. It is the link to past exam papers. Now, whilst we have a new study design and it has new topics, a lot of the stuff in this new study design was covered in old study designs, and those dot points haven't changed a lot. So looking through these past exams, basically all the way back to 2012, which was the old study design's introduction, or maybe even 2011, you'll be able to see questions on topics that we've covered in class, and they will be really similar to questions you can expect to see on the exam. So I'd highly recommend you jump on and have a gander. If I would point to a question in particular to start with, it would be 2014, the 2014 Legal Studies exam, question 13, and the question was simply, it had a bit in it about including a recent call for law reform, use of demonstrations or something like that, but the question was effectively evaluate the ability of Parliament to change the law. And it has in the examiner's report strengths and weaknesses directly in line with what we've just looked at. So I highly recommend you go and have a look at that one. Ultimately, though, hopefully through synthesizing all of your knowledge from Area 4.2 and all of the past videos, you now have the ability to answer this question. You can state how good Parliament is at responding to law reform needs, or you can state how good the courts are at responding to law reform needs, and you can back that up with evidence for both sides. This has been a final video for the Legal Studies guy. I'll release hopefully some new information in the next fortnight about some practice exams that you might like to purchase and have a look at. We'll make sure they're significantly cheaper than other providers, just so that you can get your hands on some quality resources, because practice exams will be a bit scant with the new study design. before November the, I want to say 11th, but I think that date's wrong, but maybe the 10th. All the best with your studying. Shoot us a line if you have any questions or anything's unclear. And thank you for subscribing and following along with the Legal Studies guy in 2018. Hope you've enjoyed the videos.